It's now in session. Patrick Henderson versus Diane Davies Henderson.
For the record, this matter is before the court for a continued pretrial conference subsequent to mediation. Parties have been engaged in mediation for approximately 10 minutes. Obviously, someone is not mediating in good faith. In any event, the hearing is being conducted via Zoom. The president is Attorney Matthew Biddle, representing the plaintiff, Patrick Henderson. And Mr. Henderson is present. The defendant, Diana Henderson, also is present. Good morning, everyone.
Good morning, Your Honor.
Good morning, Your Honor.
Okay, what the court's going to suggest, since this is, if I recall, it's a pretty short-term marriage.
Your Honor, may I say something, please?
Yes, Ms. Henderson?
I had not one but two surgeries on my neck in the last month, less than a month. I'm on very heavy pain medication and do not think I am able to answer legal and agree to legal things at this time.
Okay.
I had another surgery due to a complication to the first surgery last week.
Okay, obviously, the court has to move this matter along. Obviously, you could have talked with
I
Mr.
go back
Biddle.
to the doctor tomorrow. I did talk to him about it. Mr. Henderson refuses to postpone the litigation.
All right. What the court would propose this morning is that the court take the proofs and to establish jurisdiction. There's been a breakdown of the marriage. There's no minor children. That Ms. Henderson is not present. The court will reserve outstanding issues, and what the court will do then schedule a trial date.
Okay.
Your Honor.
If in fact the two parties feel that mediation is will be futile, I don't intend to waste the parties' time.
That's
Mr.
fine.
Biddle, any objection to that?
Yes, Your Honor, I do object to that. And I want to spell out a timeline for the court. Ms. Henderson was initially served in September by certified mail.
No, I was not.
He was
living
personally
here.
served.
No, I was not.
Please
Hold on,
stop
Ms.
interrupting
Henderson.
me.
Ms. Henderson, please do not interrupt, please.
Okay,
Mr. Biddle, I'm aware that the default was entered. The court ordered her to file a motion outside the default by February 16th. She's not done that, but she's here. So I can't just ignore her at this point in time. But Ms. Henderson, there are court rules you need to comply with.
Okay.
At least she's here. So the court's not inclined to just enter a default judgment this morning, Mr. Biddle, if that's what you're suggesting.
Your Honor, she's just, her intent is to delay these proceedings and make a mock.
Court's going to schedule a trial date today, Mr. Biddle.
I beg your pardon?
The court will schedule a trial date today. So we're going to move this matter forward so Mr. Henderson can get divorced.
I want to be divorced from this man.
All right, Mr. Henderson, will you both please raise your right hand to be sworn? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
I do.
Mr. Henderson, do you recall having me file a complaint for divorce in this case?
Yes, sir, I do.
Okay, and that was back in August of 2023?
Yeah, it was back this summer. Yes.
Okay, and in that complaint for divorce, there were certain allegations that we made.
Yes.
Okay, and one of those allegations was that you had been a resident of the state of Michigan for the last 180 days.
Yes.
And you'd been a resident of the county of Monroe for the last 10 days.
Correct.
Okay, you also allege in that complaint that there are no children born or adopted during the marriage.
No, sir.
You did not allege that, or are you saying there were no children?
I'm sorry. There are no children. No, sir.
Correct. You also allege that there has been a breakdown in the marital relationship such that the bonds of matrimony have been destroyed, right?
Yes, sir.
And you further allege that there remains no reasonable likelihood that those bonds can be reestablished or repaired, right?
No, sir.
You did not?
There's no way the marriage can be repaired at this point, sir.
Okay. And you also allege that there were certain assets that needed to be divided.
Yes, sir.
And you asked the court to grant the divorce. Those, is that a yes? I see your head nodding.
Yes, sir.
Okay.
Sorry.
And all those allegations, they were true at the time that that was filed, right?
Yes.
And they're still true to this day.
Yes, they are.
Okay. Your Honor, I have no further questions for Mr. Henderson.
Thank you, Mr. Biddle. Ms. Henderson,
welcome.
can you please state your name and current mailing address for the court?
Diana Henderson.
Ms. Henderson, did you hear the testimony this morning of your husband, Patrick?
Yes.
Was his testimony true and accurate?
No, it was not.
Okay, what was not accurate about his testimony?
There was no way in August he could have been a resident of Michigan for 180 days. I did not leave until April and he left after I left.
Well, Ms. Henderson, you need to file an answer. You never filed an answer to this matter.
I
so-
never received that paperwork. I was never served, Your Honor. I was never personally served papers, nor did I receive the certified mail in August or September. I wasn't even living here. I was living at my daughter's where I go back and forth.
Ms.
Your
Henderson,
Honor.
have you now received a copy of the complaint for divorce?
No, I never did.
Okay, come down to the courthouse today to get a copy. Ms. Henderson, this matter has
The
been pending
courthouse.
for some time.
Okay.
Your Honor,
That's what I was asking last time that we came in front of you about that, about not receiving it.
And the court gave me instructions to file a motion to set aside the default. And if you can't, don't do that, you need to contact an attorney, Ms. Henderson.
Okay.
Okay, Ms. Henderson, are you currently pregnant?
No, I am not.
All right, the court finds based upon the testimony that's been presented, that jurisdiction has been established and that there has been a breakdown in the marriage relationship to the extent that the opposite matrimony has been destroyed. There is no reasonable chance that the marriage can be preserved. The court will reserve all outstanding issues. Ms. Henderson, you need to take some affirmative step yourself. Come down to the courthouse and get a copy. You can look for the entire file. This is
Okay.
the first I've heard that you have not received a copy of the complaint. Mr. Henderson simply wants a divorce. That's it.
So do I, but no.
Trials. Hold on. There is only, it's a
Sorry.
3-year marriage. You were separated in March 2023. The only issue is division of personal property and some debt for a storage unit. Is that certainly the only issue?
There's
Mr.
credit
Bindo?
card debt too.
Okay.
There's, I think the storage unit debt has been resolved. We're not aware, and nor has my client alleged that there's any credit card debt.
No.
Okay. All right. So you need to present that. You need to present that to Mr.
Okay.
Bindo ahead of time, Miss Henderson. In any event, the court's going to, Mr. Henderson is entitled to a timely trial, so the court's going to schedule us for trial. Mr. Bindo.
Tell him that about the other 2 times you filed and had it pulled out.
All right. We're gonna give you trial dates. We have a date of April 25th. Are you available, Mr. Bindo? April 25th. It's a Thursday. It'll be an in-person trial. Ms. Henderson, check your schedule. April 25. It's a Thursday. It will start at 8:30 in the morning. It'll be an in-person trial.
Yes, I'm available.
Okay.
I'm available, Your Honor.
All right. So we'll mail out notice the in-person trial, April 25, 2024, 8:30 a.m. That'll be in person. Ms. Henderson, so you need to appear personally. And if you and you can always reach out to Mr. Dildo in the meantime. Maybe you can reach your own agreement. That's far better off. Otherwise, the court make a final decision and hear from both of you, and then you won't have much input other than telling your story. With respect to a trial brief, the court's going to require Ms. Henderson, for example, if you suggest there's credit card issues, you need to provide that, Mr. Bindo, in advance. Otherwise, the court will not listen to any testimony about that trial. Do you understand that?
Yes.
There are certain court rules. You need to provide that in advance. And the court recognized that the court was still ordering you to file an answer to this complaint. If you haven't gotten the complaint,
That's fine. If I could get the paperwork, I'll answer it, sir.
Your Honor,
okay, Ms.
Your Honor,
Henderson, hold on. Ms. Henderson, you appeared before this court back on January 26th when we scheduled this. And the court ordered you to file a motion set aside default, but you didn't do anything. You didn't tell me you didn't have a copy of the complaint.
Yes, I did.
And that, sir,
Sorry.
would be reason
Mr. Henderson, Mr. Henderson, please.
Yes.
You can talk to have your attorney talk on your behalf. You got an attorney.
I'm sorry.
It's not a chance for Ms. Henderson to argue with each other.
No, I'm not, sir. I brought
Right, Mr.
to you that she didn't.
No,
she didn't.
Mr.
comply.
Henderson, please, can you mute Mr. Henderson, please?
Yes, sir.
Mr. Bindo, the court's suggesting the court's going to set a time frame for each side to file a brief trial brief, so the court knows what's at issue. And you're saying that the storage unit issue is no longer an issue. Is that correct?
that is correct, Your Honor. So
from your client's perspective, what is the issue? Just division of personal property?
That's right. Is division of personal property. They have no real property. That's really the issue.
Okay. So there's property in Ms. Henderson's possession that Mr. Henderson desires?
Well, there is a Cadillac CRV or SR6. I have to look at the judgment 1 second.
Okay, there's a Cadillac at issue?
there is a Cadillac at issue, and in our proposed judgment that we were going to present that mediation today, that we prepared in anticipation of negotiation today. We changed some things on page 4 regarding the Cadillac. Initially, we were asking for that to be awarded solely to my client, and in the proposed judgment, we're asking the court to sell that, have the parties sell that, and then split the proceeds. And we were providing for a specific mechanism for that to be done through Carvana. Apparently, they've expressed an interest in it. And the
Yeah,
party
for
would split the
$5,000.
proceeds.
But
Split
Ms.
the
Henderson,
proceeds
Ms. Henderson,
50-50.
Ms. Henderson, do not interrupt Mr. Vitito.
I'm sorry, sir.
There's
Please.
also
I'm sorry, Mr. Vitito. So I'm sorry, you're suggesting the Cadillac be sold and the proceeds split equally?
that's right.
Who has possession of the Cadillac?
Ms. Henderson.
All right, Ms. Henderson, do you have any objection to that?
Yes,
vehicle
I
being
do,
sold?
sir. It was bought
Okay.
for me for my 50th birthday by Mr. Henderson. Mr. Henderson has 3 cars listed on there that he wants. One is a truck that doesn't run that he abandoned in front of my
Okay.
son's
All
house
right, you
3
answered the
years
court's
ago.
question. You answered the court's question. You're opposed to it, so the court will address that at time of trial. So you need to provide, and Mr. Vitito, do you believe, what, 10 days before trial for trial beef is sufficient?
Yes, Your Honor. And I want to point something out. Ms. Henderson came here today saying that she could not participate in mediation because she's on pain medication. She's not going to be able to understand what's going on, but clearly she understands what's going on. She's alert. She's addressing each question that's raised or that she think is being raised, and providing detailed answers. So I don't see why, based on her answers during the course of this hearing, how she cannot participate in mediation. I think it's just
It's
an attempt
noted.
for her to delay the
Your-
process.
Your
Yep,
Honor,
that's
I
noted,
also,
Mr. Vitito. Okay, so Mr.
Your Honor.
Vitito, what are the other issues other than the Cadillac from your client's standpoint?
From my client's standpoint, there's just the issues of personal property. He has disability from the Army. She's not entitled to that. That accrued while he was in the service, well before they were ever married. In fact, it accrued well before even Miss Henderson was an adult. She's not entitled to any of that. So really the only issue is the division of personal property.
Okay, primarily the Cadillac?
There's also a GM truck. It's an older model. I believe it's like 2000, maybe 2002. That's also in Miss Henderson's possession, but my client is, his position is, as of today, that should be awarded to the defendant. But obviously, that's all up in the air when it goes to trial.
Okay, so they're pretty minor. All right, the court will order Ms. Henderson, and I'm telling you right now, and what you say there's outstanding, the joint credit card debt?
yes, there's credit card debt he had me open in my name and said, oh, let's charge him up. We'll
Okay,
pay
hold
them
on.
off. And
But it's not joint debt. I asked you if there's any joint debt, and you said yes, that you opened in your
What
own
do you
name.
mean?
Is
yeah,
there any
they're all
credit
in
cards
my
with both
name.
names?
No, there are not.
Okay, and there's credit card debt in your name, and you believe Mr. Henderson should pay some of that?
Yes, I do.
Okay, you need to present that in advance of trial. If you don't provide all the documentation to Mr. Vitito, then Mr. Vitito, you've actually submitted some interrogatories, and I don't know.
And
if,
request to admit, Judge.
okay, and if
she
those
has
are
not
not
responded to
addressed, and I don't know if you've addressed that in those. If so, then it's not an issue. If Ms. Henderson does not timely respond to those, they're deemed admitted.
The deadline was Monday, and she has not responded to those whatsoever. And they address key issues, material issues to this case, and she's not addressed those. So I think those will be conceded at trial because she can't.
What are we talking about, sir? Excuse me. I don't even know what you're talking about.
Ms. Henderson, reviewing the court file, you need to check your mail. It appears from the court file, you were that mailed requests for admissions and discovery requests. You had a time frame which to respond to those, name within 28 days. If you don't respond to those are deemed admitted. So you cannot at trial argue about credit card debt if you've not responded to these interrogatories. So you need to contact an attorney today. If you can't handle this yourself, represent yourself properly, you need to get an attorney today, because this needs, if you don't timely respond to these interrogatories, they're deemed admitted. There's no discussion about the issue at trial. That's how it works.
Okay.
I see you seem to be very lucid, just for the record this morning, very capable. you know about the different
I said-
vehicles and so forth. But the
Yes,
court
I
can
know
give its
that
benefit of
stuff.
doubt. You cannot engage in mediation. You're unwilling to engage in mediation for whatever reason. That's fine. I'm not going to waste everyone's time. We'll schedule another mediation. We'll simply schedule this for trial, April 25, 2024, 8:30 a.m. in person. There will not be Zoom, but in person, Ms. Henderson, and they need to file a trial brief with the court laying out the issues at least 10 days prior. And then this,
And Your
this-
Honor,
that
the
will be
last
referenced in
remaining
the
issue that I
notice.
forgot to mention, I'm sorry to interrupt, but the other issue that will be obviously is attorney's fees for and costs for the delay that's being caused by Ms. Henderson. Obviously, a trial is going to be much more expensive for my client, who would not be needing that trial if she were willing to mediate in good faith or just conceded that she in fact was served and defaulted
I
properly.
was never,
And so my client's going to incur all those extra fees, attorney's fees and costs because of her poor behavior.
All right. Have you sent to Ms. Henderson this proposed judgment, Mr. Viddo?
We just prepared it this week. I have not sent it to her. We were going to talk about it at mediation. Literally, we had completed that this week, hoping to extend the olive branch at mediation and get this resolved. But from what I understand, she hasn't even bothered to let Mr. Walker go over that with her because she didn't want to participate in mediation today.
Okay. Well, what the court suggests, Mr. Viddo, is maybe send that proposed judgment to Ms. Henderson. Let her review it. Maybe that'll give her some time to reflect upon it, and maybe that might facilitate a resolution. You spelled out the terms that you're suggesting, that the Cadillac be sold, that she be awarded the pickup truck. So, Ms. Henderson, the court suggests, take a look at this judgment, and if you have some modifications, you can always communicate with Mr. Viddo, email or whatever. Would you be willing to mail her that proposed judgment, Mr. Viddo, just for give her something to review, and then she can even review with an attorney if she wishes?
Yes, Your Honor, and we'll send it certified because she keeps claiming that she's not getting any of the paperwork, which is ridiculous.
I did not get served. That is the only paperwork I have not received.
I hate to see you incur the expense of certified mail, Mr. Viddo. It's not necessary, but I'll leave it to you. Ms. Henderson has stated on the record her address is 43.
That is my mailing address, yes.
Okay. And you need to check your mail, Ms. Henderson. So Mr. Viddo is going to send you this proposed judgment of divorce. If you didn't look at, and I strongly suggest you read it carefully. You're not willing to discuss it today, but review with an attorney.
Okay.
All right. Anything further this morning, Mr. Viddo? I know it's frustrating, but we got a trial date set, and it'll be a firm trial date, the April 25.
And just to be clear, Your Honor, the trial brief is due 10 days prior. So by April 15th, 2024, it should be served on the other party, right?
Correct.
Okay.
All right. Ms. Henderson, do you have any other questions?
No, I don't.
All right. Put this in your calendar. The court will not adjourn this. So hopefully that some of your medical issues you will have addressed. So be prepared to proceed to trial on this date. And the court was strongly suggest take a copy of judgment to an attorney, pay a consultation fee. It's going to save you a lot of grief and stress down the road. And that attorney you can tell the attorney, okay, I've got these credit cards, and he made me take them out in my name, and whatever your position is at. View with the attorney and see what the attorney thinks. He may say you're climbing up the wrong tree, and he may say this is probably a very reasonable proposal here that Mr. Henderson has presented to his attorney, and maybe you can agree upon that, and we can eliminate this trial.
Okay.
So keep an open mind. All right. Thank you, Mr. Viddo. Mr. Henderson, that will conclude this matter. You can all zoom out. We'll see you on April 25th.
Thank you.
Thank you, Your Honor.
Welcome.